Hello, YouTube. I'm Vince White. I'm an employment attorney. Today we're talking about the New York City Fair Chance Act and specifically the amendments to it in 2021. But before we speak about the amendments, we should probably give you a quick primer on what the Fair Chance Act is. So, historically, it has always been, not always, but is for a very long time been illegal to deny someone employment because of a criminal conviction, where that criminal conviction is not related to that person's job duties or their role at a company, right? The classic example is, if you have a child abuse charge, you shouldn't work in a daycare. If you have a fraud conviction, maybe you shouldn't be an insurance adjuster, right? Like these are kind of the examples people always give when they say, what is related to a job, what is not related to a job, right? If you got in a fight 10 years ago and you want to work retail today, guess what? That's probably not going to be an issue. If you got in a fight 10 years ago and you want to work as a bouncer today, well, that's different maybe, right? We have to do an analysis on that one. And I'm not saying, any of these are definite. I'm just saying in general, that's kind of how the thinking goes. So those claims were always kind of there for my entire career at least. But often they can be difficult to prove because you have what's called a failure to hire case, right? The employer would just say, "Oh yeah, you're not a good fit." Nobody really ever comes out and says, "Hey, that prior conviction, don't want that. Get out of here. We're not going to hire you," right? That happens, right? That definitely happens, and we take those cases. Sure, those cases are, something you can really work with. But what happened a lot more often was an employer would just do a background check, find out about something in the person's history, and then say, "Hey, that interview didn't go too well." They're not going to say, "Hey, we're not going to hire you because you're criminal conviction," right? Is that just a hassle for them? It opens up this whole can of worms that they don't want to get into. So they just, "Oh, you're not a good fit. Not a good fit." And it can be difficult in those situations to prove the causal connection, right? You didn't hire this person because of her or his conviction. And you have to then kind of build that out. You have to prove that causal connection because that is what the claim flows from. Well, the Fair Chance Act, what they do in a nutshell is they say, okay, you can't do a background check until you give a conditional offer of employment. Great. What does that mean? So you say, hey, we think you're the one for the job. And out of all the people, we haven't done any background checks, so we're choosing you. And now, and only now that we've given you this conditional offer of employment, we're going to do the background check. And the offer of employment is conditional upon passing the background check, right? Again, if you're looking to work in daycare and they do a background check and you got 3 convictions for child abuse or child neglect or whatever it is, they're probably going to revoke that conditional offer of employment, and they're probably going to be well within their rights to do so. On the converse, they offer you the employment and they find out you had a police chase. You fled the police, resisting arrest. Well, if your job has nothing to do with that, if it's got nothing to do with driving or anything of the sort, then yeah, you're probably fine. You're probably fine, potentially. So there was this one glaring failure in the original Fair Chance Act, is that it didn't really deal with pending charges or charges at all, right? So let's say somebody makes an allegation against you. Oh, so and so robs banks. Maybe there's evidence, maybe there's not. It's generally going to be pretty common that you can be arrested for something based on anybody's say so. And then we have the criminal justice system to figure out if it's true or not, right? So a charge is not that meaningful. An arrest is not that meaningful. The conviction is meaningful. A conviction means you've been found guilty or that you've pled guilty, right? So the original Fair Chance Act didn't really deal with pending charges. Didn't deal with, can you be fired for an arrest? Can someone refuse to hire you because of a pending charge? And one of the amendments they've made here, I think this is very important, is they've addressed that now. So a current employer who learns that you've been arrested or charged can't act against you based on that, unless you've applied that same test. Is this related to the duties of the job? And they get into this concept of good moral character as well, right? So if you're convicted during employment, you're already working there. The Second Amendment is, you're already working there and you're convicted while you're working there. Well, it's the same test again. If you're not convicted of something tied or related to your employment, something that's kind of going to touch upon your line of work, then they can't just say, oh, you don't have good moral character. You got to get out of here, right? And that's very important too. That's the second of the amendments here. And there's some other stuff going on, but those are the two big ones. And it does specify, and this has always been the case, that employers can part ways with you if you lied to them about something, right? Like, let's say you've got a conviction and it was for stealing baseball cards, and you lied and you say, oh, it was a misdemeanor. But it wasn't. It was a felony. Well, your job might be to clean pools, and that would have nothing to do with theft of baseball cards necessarily, although I think some employers would argue cleaning pools in people's backyards would be allowing folks to case houses if they are house thieves. But, stealing baseball cards probably has nothing to do with pools. Let's say you're just cleaning a pool at a facility, and that's it. So there's no connection there. Well, the lie you told about it being a misdemeanor instead of a felony, that is going to allow the employer to terminate you. Not because of the conviction, but because you lied about the conviction. And that has always been the case. They do build that out a little bit further here. They kind of build out the process for these Fair Chance Act claims a little bit and this and that. It's a welcome update to the law. It's a law that's developing. They're still trying to figure out how to make it effective. These claims can still be somewhat difficult to bring. And I like seeing politicians iterate, right? I like them saying, hey, we tried a thing. It was somewhat positive. It could be better. Let's try to fix it, right? That's really positive. I like seeing that. And I will link to an article from friend of the channel, David, who did a little bit of research on this particular topic. And the article we're going to link it down below in the doobie-doo, and it's going to have a little extra information for you, because what I'm giving you here is just like a real cursory, the high points on what I think is important based on my practice, based on what I have seen, what I have litigated, what I've done to try to help people in this situation impacted by this law or impacted by convictions, and how that's changing the course of their career, things of that nature. But there's more to it. I'm giving you the 8.5-minute version, right? There's more, right? We can't read an entire law. We can't give you all the details on a law in 8 minutes. So it might be worth a read, and I will link the article. If you feel this video helped you, consider liking and subscribing. It does help us to help more people. Also, questions, comments. I track the comments down below. I will respond to you, almost certainly. Even if you say something horrible, I will probably respond to you. Could be funny. We're going to find out. And I hope you're all having a great day and you're safe out there. And remember, everybody works. Not everybody wins.